everyone, and welcome to Thorough Newspaper Analysis, which is brought to you by LawSikho. Let's see which all articles we will be discussing today. So we have a plethora of articles that we need to discuss today. They're really interesting and important as well. Firstly, impediments to equal productivity, dignity, which is an editorial from The Hindu, and it basically talks about providing equal access and equal rights to the persons with disabilities, and that in no way they should be thought of any less from the people who are physically or otherwise able, and what steps should be taken in this regard, and what is the current scenario in this field we'll be discussing in this. Secondly, Parliament and its panels, which is again from The Hindu, and it talks about the parliamentary committees and basically the tenure of parliamentary committees, and how having a fixed tenure or an increased tenure of the parliamentary committees would be better for delivering greater objectives. Thirdly, call is on hold, which basically talks about the telecos or the telecommunication companies in India and the current situation of the AGR issue, the adjusted gross revenue issue, and everything we'll be talking about, and how a healthy competition is really necessary to maintain a good market in this area. And fourthly, UAPA in Delhi riots, which is from again the Indian Express. So it talks about the Unlawful Activities Prevention Act and the the sheer misuse of it that is actually occurring these days, and what are the new provisions of the UAPA after the 2019 amendment. And finally, we have the News and Flash column. Let's have a look at the LawSikho courses that we have for you. So we have the Judiciary Test Prep course, which we call as the Lord of the Courses, and you can enroll yourself for it if you're preparing for judicial services. The link to this is there in the description box. You can have a look at it and download free study material for yourself as well. We are coming up with various other courses as well, and like the UPSC law optional, you can have a look at it as well. Now let's see that what is the multiple choice question for the day. Which two countries agreed for peace agreement, namely Abraham Accord? So we'll study about it also today. So which two countries have been a part of it? Firstly, UAE and India. Second, Israel and UAE, which is the United Arab Emirates. Third, Egypt or Israel. Or fourth, India or Israel. So if you know the correct answer to this question, do jot it down in the comment section below. So here is the descriptive question for the day. Discuss the various steps that have been taken by the Government of India towards the betterment and inclusion of persons with disabilities, who are also in short known as the PWDs. So you have to enlist that what are the latest steps and the inclusion steps or inclusive steps that have been taken by the government to include the persons with disabilities to the main field or the common people. Now with this, let's start with a discussion for the first article, which talks about full inclusion for the disabled. Recently, Laura Walk, basically she is the first female disabled law clerk in the US Supreme Court. She has noted that there exists a massive gap between what the blind legal professionals are capable of achieving and what they're allowed to achieve. So if we consider this, so disabilities or inequalities that the people or the person with disabilities are facing, they're not only restricted to Indian territory alone, but even in countries as developed as the United States of America as well, there are some discrepancies that exist. And as Laura Walk, who is the first disabled law clerk in the US Supreme Court, she has also noted the same thing, that if we talk specifically about the blind legal professionals, so they really are highly capable of achieving something really more, but due to various constraints. Now these could be societal constraints, legal constraints, or even constraints in the terms of opportunities as well, that they are not allowed to achieve what they really deserve. Now let's see that what are the issues that prevent the disabled from living with equal dignity and productivity. Now let's see that what are the basic obstacles or hurdles that fall in their way. Firstly is the exclusionary mindset, because obviously just take a very small example. Like if you see somebody who is visually challenged, or he is especially abled and cannot really see well, and we try to help that person to cross a road. Now, as an individual, we think very high of ourselves, and we think that we are very helpful of people. We really help people, and we really treat the persons with disabilities very well. This is one criteria. And the other people, there is another mindset that who think that anybody who, for example, cannot really see or is visually challenged cannot do some particular kinds of jobs, and he or she thinks that that person is not really capable, or he is, he is less endowed with capabilities. Now, both of these mindsets are actually detrimental for the growth of the persons with disability. Let me explain you how. What happens is that if you tend to help somebody by sympathizing that that particular person cannot see, and thus I'm helping him or her to cross the road, that is something making you feel that this person is something who is less blessed with something, who has something less, and that is why I want to help him. That basically should not be the criteria to help somebody. If we really are, of this idea to help anyone, we should really help people equally. And that is why we should not bring this into our mind that he or she is less capable of doing something, and so we need to help them. Obviously there are some privileges which we are enjoying and they might not be able to, but still an equal mindset should be there, because in a long run this also creates what we call as the exclusionary mindset. But then that also is not that detrimental as compared to the one where people, they disregard them of being capable of doing something. So this was a point of clarification, because we being informed citizens should be treating everyone equally, as in nicely and equally. So the Supreme Court in the case of V. Surendra Mohan versus State of Tamil Nadu had ruled that a judicial officer. So this is the biggest irony in here, that where through law and legal steps we try to provide equal access or equal dignity and opportunities to the disabled persons, there itself in the very same department also the idea is not equally taken. So even their discrepancies and in a way lack of opportunities is existent. So in this case, it was ruled that a judicial officer has to possess a reasonable amount of sight and hearing to discharge their function. So this is really, this is so ironical to see, because even it was held in this case that even if you have to be a judicial officer, you need to have some amount of sight and hearing capability so that you can discharge your functions efficiently. So this is obviously something which should not be bought by us. And then in the case of B.K. Pavitra versus Union of India, the Supreme Court observed that if the benchmark of efficiency is grounded in equal access, our outcomes will reflect the commitment of the Constitution to produce a just social order. So this was a really good judgment that came up, wherein the Supreme Court held that if the benchmark of efficiency, if we are looking forward to making something that is unequal, so ultimately the outcome that we will have will also be unequal in nature. But if we talk about, and if we look forward to something that is equal, then our outcomes will also reflect the commitment of the Constitution to produce a just social order. So the second one is the inability to recognize the disabled as rights-bearing citizens. Exactly what we discussed, that they also have equal rights, just as us or any other person. They also have equal rights, and that these rights should be given to them. Thirdly, non-compliance on accessibility. Now, what happens is that under the this act, which is the Rights of Disabilities Act, Disability Act 2016. So there was a section which is there as Section 46, which talks about providing all the necessary infrastructure or all the necessary facilities, and to make them accessible to the disabled people. So this was Section 46, but it has not been really complied to very nicely. And these are the recent steps that have been taken by the Government of India for the disabled, which is known as the Sugamya Bharat Abhiyan or the Accessible India Campaign, wherein, as the name itself is suggesting, it focuses primarily on making our infrastructure, now be it schools, colleges, railway stations, bus stands, or hospitals, etc. So these infrastructures should be made in such a with such specific to say facilities that they actually make it really easy for persons with disabilities to access these places. For example, if we walk on any kind of metro station, you might have noticed that in the middle of the path, like the path where you have to move, there is a metallic pathway, which actually, a person who is visually challenged can actually, through his, navigating stick, can use it, or even through his basic senses of his feet, he can understand as to where this path is going and what are the directions. Similarly, in the steps also, the staircase also, such directions are available so that they can easily access them. So this makes it easier for them to access such infrastructure, and that is why this campaign is really, really important. So with this, we move towards the next article for the day, which talks about the parliament and its parliamentary committees. So recently there were speculations. Basically, speculations is something when you try to, predict something for the future, or you try to understand or, make a guess for the future. So recently there was a speculation that the chairman of Rajya Sabha is keen to amend the rules to provide a fixed tenure of 2 years for the department-related parliamentary standing committees. Okay, so as we had also learned in our previous sessions, that there are parliamentary committees, and there are of two kinds. One are the standing committees that are permanent in nature, but of course the members change from time to time, but their nature is permanent, and the others are ad hoc in nature, which are set up for some particular purpose only. So now there has been a speculation that Rajya Sabha chairman has said that at least the tenure for the standing committees that are department-related parliamentary standing committees should be fixed to at least 2 years, which is currently just 1 year. Let's consider that what are the current rules according to which the parliamentary committees related to the departments are governed. So firstly, term of office of members. Please keep in mind that this is the term of the office of members of the standing committee and not the committee. Standing committee is a perennial body, so it stays forever. It is not temporary, it is permanent. Just the members and their tenure changes. So according to this rule, it shall not exceed 1 year. So under the Lok Sabha rules, it is Rule 331D Clause 4, and under the Rajya Sabha rules, it is Rule 269 Clause 3. So basically, as now we can see that in the current scenario, the maximum or the longest term of office for the members shall not exceed 1 year. But now this proposal has been given to exceed it for further 2 years. Now let's understand that why. This is the most important thing in this article to understand as to why this demand is being, it is coming up, and why it would be beneficial for us to have a 2-year term of office in place of only 1 year. So only once in 10 years, the requirement of major reshuffle of the standing committee is expected to coincide, because we know that in case of Lok Sabha, after every 5 years only, the composition of Lok Sabha changes only after the elections that are held for the Lok Sabha. So after 5 years, and Rajya Sabha, as we know, that after every 2 years, so in a totality of 6 years. So if we talk about a complete reshuffle, it takes actually 10 years, so which is a very long time, and that is why this time would shorten down, and it would be really possible for boosting or bringing in new members from time to time. Secondly, the Rajya Sabha rules prescribe no fixed tenure for other standing committees. So the committee shall hold office until a new committee is nominated. So this also, it makes a bit, difficult for a smooth and easy flow of the committees. Then thirdly, in Lok Sabha, committees concerned with deliberations of a serious nature were given a term coterminous with the House. So, in a way, it makes it easier for the agenda to be achieved, first of all, and then it also makes the functioning between, for example, if you talk about Lok Sabha as a house and the committees that are associated with it, so it makes it really easier and smoother for the functioning of these committees. Rather, if we talk about the standing committees for the departmental committees, they do not really hold consonance with the terms of Lok Sabha and Rajya Sabha, and that is why the functions of it cannot be achieved very efficiently. And fourthly, there are 24 department-related standing committees. Apart from ministers and some senior members, all MPs are included. So here it tells the importance of the department-related standing committees, and that is why an exceeded term to at least 2 years would actually make the functioning even smoother. So with this, let's discuss about the next article for the day, which talks about India's telecom sector. Basically, the central idea of this whole article or this whole discussion is that it is really important for the government as well as for the competitors and for all the stakeholders that are attached with the telecommunication sector, that they actually maintain a very healthy competition, and in no way we allow any kind of monopoly to exist over here. Basically, let me just give you a general idea as to what has been happening. So only a few years back, as just an example also here is given, that in 2009 there were 13 operators in Delhi. So it could be Airtel was there, Vodafone, and all other that were there. All the other operators were there. So there were 13 operators in Delhi, and due to this, there was a good competition that was existent amongst these operators, and also the consumers, the customers also had huge, they had a wider choice to choose from. Always, this can be very simply and easily related to that when there are a lot of competitors, the prices of the things or services that are goods or services that are provided, they're always, less. For example, just take a very simple example. For example, you go to the market to buy a particular shoe item. Okay, so you go to buy a particular shoe. Now you have so many options in the market. You have Adidas, you have Nike, you have Red Chief, then you might have Campus, and there are various Action, Bata. So there are a lot of varieties that are available to the consumer. Now, in such a scenario, when one company knows that there are several other companies to provide exactly almost the same product that we are also offering, they would try to make their product not only better in the terms of quality, but also in the terms of prices that the consumer can easily afford. But just imagine that there is only one company, for example, just Nike, that is allowed or that is able to produce shoes. And what could be the situation of the market in this scenario? Neither the consumers or customers will have a choice to choose from. And here, Nike will be able to develop a monopoly, what we call in the general terms, and then they can set out the prices of the shoes all they like. So, if they would want to sell the shoes for at least 10,000 rupees a pair, they will be able to do it, because people anyway, they would want to wear shoes. And since they have got no other choice to choose from, they will have to, in some other through any means, they would have to buy the shoes. So this was almost a similar situation, which actually has been occurring this time, now in today. So basically in 2020, 90% of the market share is owned by only 3 telecom companies. So you can imagine in 2009, just 11 years ago, there were 13 operators in Delhi alone. But now in 2020, 90% of the telecom markets is owned only by 3 telecom companies that are majorly Jio, Airtel and Vodafone Idea. So this is, something really very difficult, that would make things difficult even in the coming future, because as the situation is coming lately, due to the AGR dues, basically it is the adjusted gross revenue dues. This is an amount of money that the particular telecom company has to pay to the government as a license fee, because obviously if you're running and using the spectrum which is owned by the government, you're actually leasing it out, you're taking it, or just you're getting some kind of license for carrying out your business. So that AGR due has to be paid. But now currently, as we know, that Airtel and Vodafone Idea had to pay huge AGR dues to the government, and recently in the judgment, Supreme Court has provided them with a time period of 10 years to pay their leftover AGR dues. And if, just imagine if they're not able to do it, and even if they're able to do it, they actually fall in the market. A complete chance exists that a monopoly would be created by Reliance Jio, which, it would be really very good for the owner of Reliance Jio, and even for the short term for the consumers as well. But if this monopoly is created, it will be really, really difficult for us to have, even maybe the quality can be hampered, and even the cost of the services provided would be hampered. Now, why the theory of contestable is not applicable in India? Because there are a lot of entry barriers. Because, why are we not able to maintain this competition that we are actually talking about? So there are a lot of entry barriers as to spectrum acquisition cost, license fee burden that we're talking about, the AGR issue, infrastructure requirement, and policy uncertainty. So basically, in a market like India, it is not really easy for any newcomer to enter into the telecom sector and to give competition to the already existent powers. Now, what are the steps that can be taken? Firstly, for companies, augment network capacity to be ready for 5G, and for government, rationalize license fees. So in a way, it should be made more competitive. The competitors should be safeguarded. So, this is a very good thing, a very, very good idea when we say that to save or to keep the competition, what you need to save is the competitors. Because obviously, if you do not have anyone running for the race, what actually competition are we talking about, right? So here, like, whoever competitors are existent, you should provide some relaxations, like just in case they have been provided for the 10-year time period to pay the AGR dues. And similarly, you should make the environment more conducive for new competitors to enter into the market, so that no monopoly can be created in the first place. And secondly, the consumers have good options to choose from. With this, let's discuss the next article for the day, which talks about the Unlawful Activities Prevention Act. Basically, here we will discuss the main agenda of this article, which talks about the latest amendment that has come through the UAPA. So basically, let's know that what is the Unlawful Activities Prevention Act. So it is the anti-terror law. Basically, it works against or to prevent the terrorism or terrorist activities aimed at more effective prevention of certain unlawful activities of individuals and associations and dealing with terrorist activities. So it was formulated, the original one was formulated in 1967, and it is the predecessor to TADA and POTA. Now, as we know that Prevention of Terrorist Activities Act and TADA is the terrorism, and so this act, both of these, and so this is, the Terrorist and Disruptive Activities Prevention Act. So both of these were the predecessors to it. And in 2019, now the UAPA, or the Unlawful Activities Prevention Act, has seen a major amendment in 2019 itself. And these are the new things that have been added to it. Firstly, now even an individual can be designated as a terrorist. So as we know that earlier under the UAPA, only the terrorist groups or the organizations could be designated as the terrorist groups or something. But now even a single person, an individual, can also be designated as a terrorist. Then rare, often accused to get bail. Now, as we know that all the people recently who have been convicted or who have been accused under the UAPA, they have not been given bail easily, and only when we discuss the Safura Zargar case, who has been granted bail on humanitarian basis because she was pregnant, so only she has been granted bail and no other person has been granted bail, and there is also no provision for anticipatory bail in this case also. Then the period of investigation can be extended to 180 days from 90 days, which is almost it's just the double of what currently was there. Then the police custody can be extended to 30 days, which was 15 days for ordinary criminal cases. Then the NIA, which is the National Investigation Agency, can attach the property acquired from proceeds of terrorism without a prior permission of state police chief. So earlier, a permission had to be sought from the state police chief, but now the National Investigation Agency can attach the property of the, whatever property they need to attach in the course of, proceeding or investigating in a particular terrorist activity. This makes the process really faster and smoother. And then officers in the rank of inspectors can investigate the UAPA cases. Earlier, only of the Deputy Superintendent of Police and above ranks were allowed, but now even inspectors are allowed. So this is the current case, why this actually article came up from the Umar Khalid's case. You can also go through this. So these are the various accusations that have been raised on him. So you can go through this as well. Now let's discuss the news in flash that we have for today. Israel, UAE and Bahrain sign historic peace deal. So the Abraham Accord, here you might get the answer for your MCQ for the day. So the Abraham Accord is the first Arab-Israeli peace deal in 26 years. Egypt was the first Arab state to sign a peace deal with Israel in 1979. Jordan signed a peace pact in 1994. And now Israel and Arab, as UAE has also joined in. As per the agreement, UAE and Bahrain will establish embassies, exchange ambassadors, cooperate and work together with Israel in sectors including tourism, trade, healthcare and security. Second, US Open. So the winners of the US Open for the men's single is Dominic Thiem and women's single is Naomi Osaka, Alexander Zverev, Victoria Azarenka, Denis Shapovalov, Jennifer Brady and Andy Murray. Then thirdly, Lok Sabha has passed the Essential Commodities Bill. Now, as we know that it was a hugely debated bill, so Lok Sabha has passed it now. The bill seeks to deregulate food items, including cereals, pulses and onion, to raise the farmers' income and transform the farm sector. So as yesterday also we were discussing about the agricultural reforms. So this is also one very important reform in this sector. Fourthly, Aircraft Amendment Bill passed by Rajya Sabha. This seeks to amend the Aircraft Act 1934 and converts 3 existing bodies under Civil Aviation Ministry into statutory bodies. These are the DGCA, which is the Director General of Civil Aviation, then the Bureau of Civil Aviation Security and the Aircraft Accidents Investigation Bureau. Fifthly, we have the World Ozone Day today. So 16th September is observed as the World Ozone Day. marking the 35 years of Vienna Convention for the Protection of Ozone Layer. The theme of this year is Ozone for Life, 35 years of ozone protection. This is really important, can be a very potential question in prelims as well. And lastly, Kerala to have certified snake handlers. It became the first state in India to institutionalize snake handling in the country. The guideline makes it mandatory for snake handlers, between the age group of 21 to 65 years age to seek certifications. This is something there are now for which they can have a certification as well. So Kerala has reported 334 deaths and 1860 other cases of snake bites during the last 3 years. So this is really huge, and that is why it is really important to have certified snake handlers over there. So this was all for today. We hope it was an informative session for you all. Thank you so much for staying tuned with LawSikho.